so nice to have you back with us. Today we have a neighbor, and his name is Rafe Foreman. And Professor Foreman is the Douglas Strip Dean's Distinguished Professor and Director of Advocacy at the University of Missouri Kansas City School of Law. That's a mouthful, Rafe.
It is a mouthful. I didn't come up with the title.
And the most important thing is that he was, and still is, a very fine lawyer. He is interested in criminal defense, plaintiffs' personal injury, civil rights, employment, discrimination, wrongful death, and excessive force. That's a lot of stuff, too. You got a lot of mouthfuls here.
Yes, ma'am.
And he had the good sense to take some advanced education in psychology because he sees a lot of trouble in that office. And he also is very proud of being a graduate of the Trial Lawyers College, and he now serves as an instructor as a board member.
Thank you.
I think I got it all in.
You did.
He does some interesting things at UMKC. He teaches practical application of the law rather than just theory. And I think that from reading about you, you find that very interesting part of UMKC, that they do teach practical application so these people can go out and do something.
I sure do. I'm very proud to say that some of my students have already tried their first jury trial before they even have a law license. We have a rule in Missouri, Rule 13, where you can actually apply for, as a third-year student, an opportunity to try a case with supervision of a licensed attorney. And I have 7 or 8 students who have already tried a felony case here in Jackson County.
Well, and you have to say, you know, you can go through law school, but to learn to practice law that's the key.
That's right.
And often they can't, and that gives them a really very important leg up.
I agree. We're trying to produce trial-ready lawyers out of our advocacy program. You know, when I graduated law school, the firms would hire you and wait 2 or 3 years before you'd ever get to go to the courtroom. Not now. These lawyers are ready to go to the courtroom the day they come out.
They're ready to go. And somebody said to me one time that to learn to practice law, the best place to learn is in the prosecutor's office because you have to do everything.
Well, that's right. Not only that, but you're going to get to go to trial immediately.
That's right.
And so if you want some trial experience, it's a great place to gain trial experience.
And you know, it's scary that first time.
Oh, it's scary every time for me.
Is it?
It is.
Hey, that's good.
If you ever lose your fear, I think that maybe there's something wrong.
You may have lost your zip.
I think you've lost your zip, or maybe you don't care. I can't see how you can go have another person's life in your hands and not be scared.
Well, and that is a very good segue into the personality of Rafe Foreman, who cares very much. And he cares very much about certain things. Cares a lot of things, but about certain things he cares even more. And one thing that you care about is the unfettered, and I like that word, we need to discuss that word, the unfettered right to trial by jury.
That's right.
Why unfettered?
Because I'm going to use another word I like. If you
Okay.
tinker with something that's perfect and working, you mess it up. And like my daddy would say, if it ain't broke, don't fix it. Well, our jury system wasn't broke in the United States at all. Our government was set up for the people, by the people, and of the people. And it's a system of checks and balances. For example, if we get the legislative or the executive getting out of hand, the judiciary is where we correct those things. And we have a system of checks and balances. When you take away the power of the people by limiting their opportunity to engage in this checks and balance, the whole system gets out of whack. And I'll give you an example.
Okay.
For example, tort reform operated under the guise, and I say the guise, that we're going to lose all our doctors if we don't implement tort reform. And so what they said was the price of killing a baby at birth, and I'm talking about not a good doctor, I'm talking about a negligent doctor that a jury finds is negligent.
And now we're talking about a perffictly healthy baby.
Perfectly healthy
Yes,
baby
'cause I
that
wanna
should
make
have
that
lived in
clear.
all ways.
Okay.
Most you can recover is $250,000 for that. And the whole lie that they told us was that if we don't get insurance premiums down by passing this tort reform, we're going to lose doctors. Well, they passed tort reform, and guess what? Not a single dollar has been saved in insurance premiums. In fact, they just continue to climb. And so the public was duped. Now what we have is a system that does not operate functionally as it was designed to operate because we have a limited right to a jury trial instead of an unfettered or unlimited right to a jury trial.
Okay, let's go back a minute. I want to examine the limited right. Are you talking about a trial by judge? Are you talking about a change of venue? Are you talking about
I'm talking
plea
about
bargaining? What makes it limited?
The amount of money that a jury
I
can
see.
award.
Okay, we're back on the tort reform.
Right. For example, in our country, a jury is the only body that can sentence a man to death. Well, what we're telling our jurors and our people is that you're smart enough to tell us if this guy lives or dies, but you're too stupid to determine how much money is the value of a baby's life is worth. And that's what we're doing. And I don't believe that. I believe that the people are the best arbiter of these disputes. Only the people, because that's the way our entire system of government was set up.
Okay, there are those,
right,
Professor,
no, I agree,
who would say to you, you know, sometimes you get these people on a jury that are just downright ignorant. They don't read anything, they don't know anything, they can't make a good decision, and yet here we are stuck with a jury to decide sometimes life and death, sometimes other serious matters. How do you respond?
Are those the same people, Mary, that are electing these people that are in Washington and
well,
in Jeff City,
in some
and
cases,
they don't
yes.
read, they're not educated,
in some cases, yes, and that's a whole different problem. They do.
It's because our power is granted into a jury of our peers. It's not a jury of the people we think are smart enough. It's not a jury of the people that we think are educated enough. It's not a jury of the people that we think are deserving or worthy enough. It is supposed to be a jury of our peers. And in our society, we have illiterates and we have extremely educated people. And if we are going to have a jury of our peers, as our system was designed, we have to include all people, not just the elite that we think are smart enough to determine these disputes.
In other words, Jesse Jackson's entire rainbow?
Yes. I'm not saying that I'm sponsoring Jesse Jackson's rainbow theory.
I
However, I am saying that of the people means all the people.
Yeah.
All men are created equal.
Well, let me
not
ask
some.
you. Let me ask you this question. You try a lot of cases.
I do.
Are there enough who say, "I renounce my right to a trial by jury and have just a trial by the judge"?
No.
Most of them want that trial by jury. They have that right, do they not?
Of course, they have the right.
Yeah.
I don't think that many people choose to have a trial by judge. Let me tell you why.
Okay, I really.
This is also why we don't need tort reform. We already had a checks and balance that takes care of this. If a jury, for example, does the wrong thing, they give too much money, the judge can set it aside. It's called a judgment notwithstanding the verdict. We've always had that right. And so if you have a jury trial, you have really had both. You get a trial by the jury and a trial by the judge. And so the judge always has the opportunity to set aside the verdict of the jury and say, you disregarded the evidence, you didn't pay attention, something was wrong with y'all, you were influenced by an outside or illegal influence, and I'm going to set aside your verdict. The trial judge has that opportunity, always has, always will. Then we have appellate courts and the Supreme Court that they can appeal that decision. But what I want to focus on is, again, the lie and the misrepresentation that's been given to our community, that we have to fix these runaway juries or these stupid people that don't know what they're doing. What you're really saying, what the truth is that you have no faith in your judge, because the judge has the power to fix all of those things.
Well, hopefully, do you find the judges worthy of faith? I mean, I'm not suggesting they're not, but I'm asking you.
No, I love the question. In Texas, no. Because in Texas, it's a purely political system. The person who has the biggest corporation that writes the biggest check gets elected, and therefore the judge is beholden to the corporation that bought them the office. That's not what we have in Missouri. In Missouri, they have a much more enlightened, it's called the Missouri Plan. And I don't want to go into all the details of how a judge is appointed, but in Missouri, judges are appointed by a panel, and then there is a retention vote. And so judges here are much more non-political. They are much fairer. And I'll tell you, I've tried a bunch of cases in Missouri and many in Texas, and there is a strong differentiation between the quality of judges that I see in Missouri. Missouri has outstanding judges, and Texas has some outstanding judges. I don't mean to wholesale throw
we
all
don't
the judges
wanna
under the bus in
damn
Texas.
them all.
No, I don't.
No, we don't. Yeah,
But the system of how judges are elected is what I'm speaking to now.
Well,
and
Kansas,
Missouri has a great system.
Kansas has a very similar system. They are selected by a panel and submitted. 3 of them are submitted to the governor.
Oh, okay.
And then the governor appoints one of those, and they do have a retention vote.
Right.
In Kansas as well.
In Missouri, I understand that formerly the Supreme Court, the Chief Justice of the Supreme Court, had a vote in making that decision, and I just think that's logical because he is a product of the system,
or she,
or he or she is a product of the system that is nonpartisan, versus the governor, who is a partisan elected official. But still, both systems in Kansas and Missouri, I think, are superior to the outright election.
I think so. I do, because when you get involved in an election now, Kansas is not uniform. In other words, the district judges in some of this in Wichita and in Wyandotte County in Kansas City, Kansas, are elected. So, you know, it's not uniform, but most of they are appointed. In Johnson County, they are appointed.
Right. Well, this is a sore spot for me because I tried a case with my law partner, Susan Hutchison, about 9 years ago, and the jury returned a verdict. The case has been appealed repeatedly to the Supreme Court and the Court of Appeals. This is down in Texas. And the appellate counsel that they hired just so happens to be one of the top 3 contributors to the judges on the Supreme Court.
Yeah.
Well, in the law and in advocacy, we're supposed to avoid the appearance of impropriety. And that just doesn't smell right.
Yeah, but Rafe, politics in general has that problem because in order to get elected today, we're talking about getting elected here, take away for what?
Right.
In order to get elected today, it takes a lot of money.
Which is
and
why
they have to get it from somewhere.
That's another problem that we have. That's another tinkering with our system. I have a proposal.
Oh, good.
For every dollar that you spend on advertising and running for election, my proposal is that you would have to put a matching dollar into the general fund. So if you want to spend $1 billion to run for president, put the first $1 billion, put it in the general treasury, and then you can spend $1 billion. And the reason that I say that is we have denied a person like me would never be able to elect a person to office, nor would I be able to run for office because I don't have the independent wealth. And I don't think only the wealthy should govern and only the wealthy should rule. I think that people should have an equal opportunity to have a voice in elections.
Well, it might be said that you don't have the independent wealth, but you're too independent.
Maybe so.
That doesn't always work either.
That's right.
But I do have to. I want to go on to tort reform because I think let's define what tort is because I'm not sure that everybody understands what tort is.
I didn't know what it was when I went to law school, so I wouldn't want anybody to feel left out. But I thought it was some kind of dessert. But a tort is a wrong done by one party, one person, one entity to another. For example, if I run over you, if I'm not paying attention and I hit you at a stoplight, that's the tort of negligence. If I am harassing you in the workplace based on race or gender, it could be a sexual harassment or racial discrimination tort. And so a tort is literally a wrong done by one entity or person against another.
And the ability of the court or the effort by the court to right that wrong.
That's right. The injustice that is created by that imbalance of power or the negligence, for example, and cause the damage. In the civil justice system, the only thing that we can do is return money which stands in for the loss that was suffered. We can't, for example, if a doctor kills a baby during childbirth due to negligence, we can't bring the baby back to life. If you ask the mom and dad, I promise that's what they want. But the only thing that we can do is award a dollar value that represents the loss that was taken because they took a life without permission, without consent, and needlessly. And so what the money is in our civil justice system, it's a symbol that represents the value of the loss.
Well, and I read, and maybe they use actuarial tables for, let's talk now about an older person.
Yep.
Middle-aged, let's say, 40, 45, 50.
How about 72?
Suits me.
Okay.
But actuarially, they live so long. Therefore, a monetary value is attached to that life.
Right.
Or the earning capacity of that person during his or her lifetime.
Right. I understand the theory.
Yes. So I just want to reiterate.
No,
Teachers,
I agree.
But how do they decide? Because I see in the paper where $1 million, $2 million settlement is made in a wrongful death.
Which is low, probably.
Well, probably.
I mean, I can't imagine anybody's life's only worth $1 million. That's just my opinion.
Well, I understand.
Let me ask you this. You've got a 72-year-old that's dead and a 10-year-old that's dead. Which one's more valuable? Well, maybe you might say the 10-year-old because he lost the opportunity at his life. However, if I'm 72, every day of my life is more valuable than the last.
Well, and you may be responsible for others as well.
That's right.
So
you may have 2 or 3 families or 2 or 3 people,
right.
depending on you.
Well, the point is that tort is a very elusive subject because it is extremely difficult to decide fairness.
No, that's right. And that's why we need a cross-section of people to determine it. Because, for example, if you have only the people that belong to the country club and all have 401ks and all have retirement and only are a one-income earner household, they may not think of the issue in the same way as the person who is supporting 3 families in a one-house situation and where everybody works, pools their money, and works together. And that's exactly why our government was set up to have a cross-section of people be on our jury.
And we can't always agree with every decision that's
No,
made.
that's right. In fact,
and that I think is a real issue.
I agree with you. I think that, for example, if you and I are trying to settle a dispute and both of us think that it wasn't really fair, it's probably a good deal. Because if one of us is really happy, then there was a power imbalance and perhaps one took advantage of the other.
We're always weighing the heart against the feather.
That's right.
So, yeah.
And I don't think there's anything wrong with that.
I don't either. Robert Burns says, man's inhumanity to man makes countless thousands mourn. And another subject that you are interested in is advocacy.
Yes, ma'am.
And I want you to talk about, because you run the advocacy entity at the law school.
I do.
And I want to know why you're interested in that and what really do you define advocacy?
That's a great question. Advocacy reaches across so many boundaries and it applies to so many disciplines in the law school. For example, advocacy may be being an advocate in the trial court for the damned, the downtrodden, the wrongfully accused, the person with no voice. But advocacy is also applicable to contracts. The person who is a better advocate in a contract has a stronger position to enforce the contract, for example. Advocacy also applies in the family law situation. A better advocate is going to obtain more child support, more visitation, more health benefits for the child in a separation situation than a non-advocate. So advocacy reaches across, I think, every discipline in the law school, and it touches every aspect of our life. For example, when you watch a commercial on TV and they're advocating for their product, they charge for it, so they call it advertising. And so what they're doing is they're trying to show you the strong points of their product, and that's what we're trying to do in our program. We're trying to put forth the strong parts of our case, of our motion, of our contract, of our argument, whatever it is, we're trying to enhance. And there are several ways that you can do that. One is communication skills. We stress communication skills because if you can't communicate your point, you can't prevail. I don't care if you're the smartest lawyer in the world. If no one's listening to you, no one cares what your point is.
And some of these kids stare into a box too long and don't talk to people very much, and it's really difficult to communicate.
Well, and I don't know what happened. You know, my mom and dad used to teach me how to communicate with adults when I was a child, and I don't see that. All I see now are people into their crackberries or their cell phones or playing.
I call it happy thumbs.
Yeah, whatever it is they're doing.
But their eye-hand coordination is wonderful.
Yes, it is. But their communication skills are terrible.
Terrible.
And
terrible.
They don't know how to relate, and that's another part of advocacy. Persuasion is only a piece of advocacy. But for me to be able to persuade you, you have to, A, connect with me. You have to care about what it is I'm trying to talk to you about. And we have to have a relationship. And I don't mean that in a weird way. I mean that we have to have
be able to
an exchange and communicate.
That's right.
I have to be willing to listen to your ideas, and you're willing to listen to mine, and we come to some consensus or some resolution, and that all involves strong communication relationship skills, which we try to teach at the law school.
The other thing you mentioned, I want to go back to, there's
Sure.
another thread there. You're talking about contracts and negotiating and all that, and you're talking about pulling out the important points. That can be taught, and that is really important, because in a contract, some of it isn't so important,
Right.
and some of it is. And the way in is easy, but the way out is sometimes difficult.
That's right.
So you have to be able to pick out those. And how do you teach them to, or do you find they know?
Oh, no, I don't think they know. I think it has to be taught. And I think our writing professors are top notch at the law school. I think our contracts professors are exceptional. And let me tell you about my experience with that. There's a lot of things in the law that we call boilerplate language.
Yes.
And okay,
We pull those off of Westlaw.
Exactly.
Yeah.
You pull them off of Westlaw, you pull them off the internet, you steal them off a contract that somebody else had last week, you know. Oh, that sounds good, throw that in there. And like a force majeure clause, you know, they always put a force majeure clause in there. So if, you know, a flood or lightning or a hurricane tears up the business, all bets are off.
God points his finger at you, and
God
it's all
points
done.
his finger at you, it's his
all
fault.
done.
Yeah, it's all done. So I understand the need for those, but the real nitty gritty, what contracts generally come down to, and I usually see a contract when we're going to court. You know, I'm not usually involved in the drafting of the contract. I'm involved in the enforcement of the contract. And so when we get to court, it's always the provision that somebody lined through and initialed, or a special provision that was particularly drafted for this contract, because the specific governs over the general. So if you have all this general language that's just boilerplate, meaningless stuff, it's the specific language that's going to govern over the general, and we need to teach students to pay attention to that, focus on that, and talk particularly, if we're going to sell, if you and I are going to make a deal for this table, the language that deals with this table, price, date of delivery, method of delivery, are the important parts of the contract. Not so important are the general terms of, you know, well, we're open from 8 to 5 on Monday through Friday, and you can come pick it up from 3 to 5 at the loading dock in the back, you know.
So to clarify, there is nothing inherent in a contract?
Well, I wouldn't say there's nothing inherent.
Okay.
I think there are some inherent requirements to making a good contract. A good contract always has to be based on a valid offer and acceptance. And a lot of times it breaks down on what was a valid offer, what did you intend, was it a unilateral offer or was it accepted? And once it was accepted, now we have a binding contract if we have a, quote, meeting of the minds.
So if I want to go back, I'm not satisfied
No,
with you
that's
yet.
fine.
What isn't specifically stated is inferred? Can be inferred?
No, ma'am.
No, okay, that's where
The
I'm
way the
going here.
rule works is that the contract is going to be interpreted against the drafter. So if you draft the contract and it wasn't specific enough and that hurts you, it goes against you.
Too bad.
Yeah, because you're the one that drafted it up.
So we're right back to those important points again.
Exactly. That's why it's critical.
Yeah.
And you can't anticipate everything. You know, I don't want to give anybody the impression that, well, I've got a bad contract because this scenario that happened to us wasn't anticipated. You can't possibly anticipate everything. I mean, who in the world would think that radon gas is going to be the reason that you can't sell your house? You never heard of radon gas. Nobody ever told you about radon gas. Yeah. And then you go to sell your house and you get an inspection and they say, oh, your house has got radon gas, you can't sell it.
I want to ask you a question. You have tried, and do try a lot of cases.
Yes, ma'am.
Yeah, and you don't have to mention any names, but sometimes those cases, I am sure over these 20-some years, you've had some really interesting things come before you to sort out, if you will. Can you think of one in particular that comes to mind as one of the most interesting cases that you have ever had?
You want a criminal or a civil case?
Criminal case.
Yes, I represented it was a serious felony case. I represented a county official who was charged with embezzling over $500,000. That's over $500,000.
That's a good.
And if you set that out in the denomination, that's quite a stack of money. I mean, it's more than a briefcase full.
It's more than I make in a year.
Yeah, it's more than I've ever seen. So it's a lot of money.
Yeah.
And the case lasted for about 3 weeks in a trial, including the pretrial hearings, and all of the officers of the county came to testify against her. My theory was she's the only Hispanic woman in an all-white county, and she plays bingo, and their whole theory was that she spent $500,000 playing bingo. Really? I mean, it's because we don't have casinos in Texas.
Yeah.
So we tried the case, and she was acquitted on all felony charges. And so it was an interesting case because it was the power and the might of the government against one little helpless woman who just had innocence on her side.
And you won the case for her.
Yes, ma'am.
I just think that is wonderful.
And she refused to plea. They offered her many a plea.
Because she said, I wasn't guilty.
She said, I
and
did
I'm
not do
doing
this.
It. And that, did you encourage her to take a plea?
No, ma'am. I believed her.
So we can. But
And
see,
what made the difference is when we stacked up the money that they would say she would steal $10,000 a day, and her boss, their desks faced each other. So just like you and I are sitting, her boss would face her every day. And I'd set this stack of money up there and cross-examine her, and I'd say, okay, she stole a stack of money this big? Yeah. Right in front of you? Yeah. Where'd she put it? Well, I don't know.
So we're talking about stealing cash. We're not talking.
Cash.
See, that is.
Over a period of about 8 months.
But see, the point here is the power of the government against an unempowered person.
That's right.
And that happens more often than we would like to.
Unfortunately, it does, and that's another part of the advocacy program that I want to teach. You know, advocacy for one is advocacy for all. I'm not advocating being against any group. What I'm saying is, when right is right and innocent is innocent, don't be copping a plea. Don't bail out. Don't compromise, because this system works if we'll quit tinkering with it.
Well, and sometimes court-appointed attorneys are not the best either.
Well, now, I don't want to rag on court-appointed attorneys. I will say this.
Yes.
If a court-appointed attorney was given the same resources as a prosecutor, we wouldn't have the problem you're talking about.
Well, and
if the government paid for the same amount of investigators, the same amount of police investigators, the same salary, and if they were on equal footing, I don't think we would have the problems that you and I do know exist.
Well, I think you're probably right. I do. But I have to say that if you aren't encouraged to study the law after talking to Rafe Foreman, then I don't know what I can do for you, because he is one heck of an attorney, and he is very passionate about what he does. He's a cowboy, he's an athlete, he's an auctioneer, he's a lawyer, and he cares above all else about justice, he shalt, and we shalt, and you shalt pursue for the damned, for the unpopular, for members of society who aren't getting access to justice. So thank you. And thanks to the UMKC School of Law for allowing us to ask you to come and visit. And I would encourage you to follow him in the newspapers. You see an article about him every once in a while. And I'm so pleased that he's our neighbor and that you're our neighbors, and we could get together today because you know it's our community. We'll see you soon again.